He is now in session.
Thank you, Mr. Hibner. And on behalf of Judge Bennett and Judge Davis, I'm pleased to welcome Mr. Herbert and Mr. Rader to this oral argument, which we are conducting via Zoom and which is being live streamed to the public so we can maintain our obligation to hold open court. We will conduct the hearing in the same manner as if we were all in the courtroom together. Each of you has 15 minutes for your argument, and I understand the appellant has reserved some time for rebuttal. So we will ask Mr. Hibner to call the case.
James E. Cryer versus the City of Algood, Tennessee.
Mr. Herbert, you have the floor.
Good afternoon, Your Honors, and thank you for your time. Thank you for hearing us today, and thank you for accommodating us over Zoom during these times to have this case heard. On behalf of the appellant, James Cryer, my name is Eddie Herbert. Mainly, I would like to rely on the brief that was submitted. I know it was lengthy. This is my first appeal, and I felt that I said most of what I needed to say in that. But today, I did want to emphasize several of those points, as well as address, obviously, some of the points brought up from the City of Algood's reply brief. The issues today are essentially that the trial court erred in this GTLA action bench trial, and that the available objective evidence supports another finding of fact with a greater convincing effect. And that is what we are asking the Court of Appeals to do today, is to render the judgment that the trial court should have rendered. That finding is that Officer Ferguson's multiple negligent acts and omissions were not only the proximate cause of this crash and the injuries of James Cryer, but that there is more fault attributable to Officer Ferguson for his multiple acts of negligence and acts and omissions. As the court knows, the standard of review is de novo with a presumption of correctness, but with the available video evidence from this case, there was video cameras with two different angles after the entire crash. With that documentary evidence and as well as the data from the airbag control module of the patrol vehicle, the implication of this deferential standard of correctness is not implicated, and Your Honors can review this and review that video and that data and draw your own conclusions, and that is what I would ask you to do. With that presumption, there's also a presumption of the credibility of the witnesses. As you know, the trial court is in a better position to see and assess these witnesses. But one of the things I wanted to point out and emphasize was as to the credibility of Officer Ferguson, where the trial court found him to be a credible witness, while the trial court did find him guilty of certain instances of negligence. I think speaking to his credibility is something that I wanted to bring up today in this argument. You'll see.
Aside from speeding, what did the officer do that constituted negligence?
There was speeding. The testimony at trial was that he had to have been somehow distracted or inattentive. Some of the contradictions in his testimony were essentially that he saw the speed limit was reducing from 55 to 45 to 40. He saw the warning sign for that. And in their reply brief, they said that he simply hadn't slowed down yet, but he testified that he was maintaining that speed of at least 60 miles an hour because he thought he was still on 55, although he saw the warnings that it was going down from 55 to 45 and then subsequently to 40.
At the exact location of the wreck, what was the speed limit?
40 miles an hour, and that was undisputed and had been for some time. You'll also see in the testimony that he had previous incidences of avoidable crashes that had already had impacts on his career, and so he was certainly aware that another avoidable crash could have even more adverse effects on his career. The objective data, the video, and the testimony, the evidence that is all available contradict most of what Officer Ferguson testified to about this crash. As I mentioned, he said he hadn't slowed down yet, but he also said that he was maintaining that speed through this area. Furthermore, the data from the airbag control module, which is only a 5-second clip. So when Officer Ferguson says he was traveling at 60 in the 55 mile an hour area, there's no way for us to know that using the data. The data only exists 5 seconds back, and that data has him north of 60 miles an hour the entire time. And even Sergeant McFarland characterized that as maintaining his speed through this area. So if he says he saw the slowdown warnings to 45 and then to 40, but was just still slowing down, but still maintaining his speed. Another contradiction was that he testified that he was going with the flow of traffic, whereas in the video you can see that he passes the black car, which is talked about at length in the brief, at an extremely high rate of speed. And I think it's likely that he was simply riding in the left-hand lane, not going with the flow of traffic, but driving excessively, passing every car that was out there.
Mr. Herbert, I would like to ask you about the proximate cause issue, because I think that is what the trial court seemed to focus on.
Yes,
and specifically, one of the cases cited by the appellee, which I think is interesting, is that Bennett case, which was the ambulance case where the ambulance had responded to the car going off the road, and they blocked a lane when they did so. And then lo and behold, somebody else comes across and runs into the ambulance. And what the court said in that case was, even if the ambulance attendants were negligent in parking their vehicle in the westbound lane, they had a right to presume that people traveling eastwardly would stay in their own lane and not violate the rules of the road. So the court said their actions were not the proximate cause of plaintiff's injuries. And I think that's what the trial court is saying here is, yes, even if we assume that, we know that the officer was speeding, but she's saying that the proximate cause was in fact the actions of your client in pulling out in front of the speeding car's lane of travel.
Yes, and obviously that's where we disagree. And as to the Bennett case, the Court of Appeals actually ruled that the ambulance was not negligent. The trial court ruled that they were negligent, but it wasn't the proximate cause, where the Court of Appeals said that what they did, the way they parked, preserving and protecting the accident scene, and the fact that this injury happened, I think, within 2 minutes of them arriving on that scene, that the eastbound lanes were completely unobstructed. The Court of Appeals actually found that there was no negligence, and that's why there was not proximate cause on behalf of the ambulance. I think this is differentiated because the ambulance drivers were there responding to an emergency, which I have a lot about that in my brief as well. Officer Ferguson was not responding to an emergency, but this was the functional equivalent of a high-speed chase without him using his lights and sirens. The danger to the public is still the same. During a high-speed chase, the lights and sirens are there to tell everybody, here I come, I'm speeding. And even then, he still has a duty to drive with reasonable care. Back to the Bennett case, the Court of Appeals found that it wasn't negligent, and therefore I think that rule should not apply to or benefit Officer Ferguson. He essentially shouldn't have a benefit because he was speeding and inattentive and distracted while not in an emergency. I don't think that should be a benefit to him. If anything, even if he was on his way to an emergency, there would still be an argument that he has more fault attributable to him in this case.
What was he distracted by?
He says nothing, but when you watch the video and the testimony of Sergeant McFarland was that there must have been some level of distraction. And I do agree with the trial court. The trial court also found that there must have been some level of distraction because he says he saw the speed limit warning signs, but never saw when the speed limit changed. And while he testified that he took these evasive maneuvers of turning the wheel to the right and hitting the brakes, when you watch the video, there's absolutely no movement of the patrol car whatsoever, no slowing down, as if he didn't see the SUV right in front of him at any point whatsoever. The evasive maneuvers he said he took, Officer Ferguson was never investigated or questioned by the THP or the CERT court. He testified that he told his supervisor, hey, I was speeding when this happened. But he didn't tell anybody that he took these evasive maneuvers of braking and turning the wheel until these proceedings started and the CERT report had been completed and apparently or presumably reviewed by him. Another argument that the appellants make in their brief is that Mr. Cryer is somehow an intervening or superseding cause. And I wanted to address that real quick. There's a case of Potter versus Ford Motor Company that I can share with the court, that an independent unforeseen cause is, and the intervening cause analysis is inapplicable to a case discussing the plaintiff's negligence. And even if that case isn't directly on point for the factual scenarios, I think arguing that Mr. Cryer's fault or negligence is unnecessarily duplicative because we already have the comparative fault system. And I make no qualms about this being a comparative fault case, and certainly Mr. Cryer may have some fault in this case. But I think when you look at the objective video, the objective data, and the available evidence, I think that the clear attributable fault lies much more on Officer Ferguson, his conduct of the excessive speeding, 26 miles an hour over the speed limit through a commercial area that he was unfamiliar with during a business hours. There's no access roads. These cars are coming directly out of the businesses onto the main roads. And I'm happy to take more questions during my rebuttal time.
Thank you, Mr. Herbert. We'll now hear from Mr. Rader.
Thank you, Your Honor, and may it please the court. My name is Danny Rader, and I'm here today with my law partner, Andre Greppin, who's off camera, on behalf of the city of Algood, and appreciate the opportunity to be before you today. Judge Davis, I think this is my first time before you, so it's nice to meet you. Of course, you all have seen the video. It's a dramatic video at full speed. What the trial court had the opportunity to do over the course of a day was to listen to all of the witnesses and watch the video with each of the witnesses and watch it in slow motion. We've provided in the trial exhibit a slow motion synced video so that there are two views so that it can be watched and can be taken piece by piece to see what exactly happened here and how this wreck came to happen. We're fortunate to have that video. And obviously we've provided screenshots from the video, pretty high definition photographs. They were exhibit 4 to the trial court, and several of them are identified in the brief. But what's important today is that the trial court heard all of the evidence in the case. She heard from all of the witnesses who had anything to do with this accident. She heard from the plaintiff, Mr. Cryer. She heard from the defendant driver, Officer Ferguson. And she heard from this independent expert who is the THP CERT officer, John McFarland. He was not engaged by either party. He investigated in the course of his job as the THP, and he was a qualified expert accident reconstructionist, and he testified. And his conclusion, independent of the trial courts, was that the plaintiff, Mr. Cryer, was 50% or more at fault for the accident, that the Officer Ferguson was less than 50% at fault for the accident. And that comports with the trial court's dual ruling. Number one, that Mr. Cryer, the plaintiff, was the proximate cause of the accident and not Officer Ferguson speeding. And separately, the trial court found that even if there were proximate cause on Mr. Ferguson's part, that Mr. Cryer's negligence and his fault still was greater than 50%, and that still bars his claim. So those are two independent grounds to support the trial court.
Rader, let me ask you this. We know that the officer was speeding.
Yes, ma'am.
That's admitted, and you can see it clear as day in the video. But what's interesting to me is both the video and your expert testified to the fact that if the black car that was at some point parallel to the officer's car was able to come to a complete stop in plenty of time to avoid hitting the car. So if the officer had been going the same speed as the black car, then presumably and I think the testimony says that. In fact, the expert says, yes, if he had been going 40 miles per hour, then he would have been able to stop and avoid the accident. So that's the part of this that I'm a little leery on in terms of the result from the trial court, because how do you ignore that?
Well, I don't ignore it, Your Honor. And I think that, of course, the Ferguson car was parallel with the black car at some point in time. But at the point that Mr. Cryer pulled into the path, it's reflected by the video, and it's photograph number 10 of exhibit number 4. And I don't know if you can see it here, but you can see in this exhibit 4, photograph number 10, that the Ferguson car is substantially ahead of the black car at that point. And it is not parallel. The Ferguson car is way ahead, and several car lengths ahead, as the oral testimony was from Mr. McFarland. And so it's a misnomer to say that they were parallel so the black car could get stopped. At the time anyone had any knowledge that Mr. Cryer was pulling into the road, the Ferguson car was ahead, and so it wouldn't have made a difference. and didn't make a difference. I think what the testimony was is that perhaps the accident could have been avoided by a hair. Mr. Cryer could have maybe just skated past. But of course, as Your Honor knows, that's just as dangerous, if not more dangerous, than staying there as well, because that could cause an evasive maneuver. Somebody could swerve into the oncoming lane of traffic. There's that equal or more serious danger. And if you look at that photograph number 10, that's where Mr. Cryer's wheels first cross what is called the fog line and get in the road. It really was more until you get a couple of feet of the car in the road before someone would really notice that they're coming on in, as opposed to inching up. And so the oncoming drivers, both Mr. Cryer and the black car, wouldn't have had that opportunity to know that, Mr. Ferguson and the black car wouldn't have had the opportunity to know Mr. Cryer was pulling into the road until he had gotten out there further. And by that point, the Ferguson car was so far ahead of the black car, I don't even think that that's a fair comparison. And I think the trial court realized that when she looked at the slow motion videos and looked at and parsed it all. And I think that's important.
The expert did say, though, that he calculated that if the officer was going 40 miles per hour, he would need 250 feet to stop. And he determined that he was 300 feet when Mr. Cryer first pulled into the travel lane. So he says as long as he sees him, he's able to hit the brakes and bring his vehicle to a stop without hitting the Cryers.
And that assumes, number one, that Ferguson could see Cryer. It assumes, number two, that Ferguson was 3.3 seconds. That's the figure that the officer used from using his stopwatch, 3.3 seconds back. If you look at the timestamp on the video itself, it looks like it's closer to 2 seconds. And we discussed that at length in the testimony, and the trial court considered that as well in making her findings. And so, that's not mathematically exact, but that's a legitimate argument that maybe there's a chance they could have stopped. But that's why the trial court listened to all the witnesses, made the credibility findings, and made the determinations. The trial court did find Officer Ferguson was credible about this accident, and she implicitly found that Mr. Cryer was not. And where that came in was on page 199 of the trial transcript and the trial testimony. Mr. Cryer denied that his vehicle had started to move before that white van. If you watch the video, he's waiting for a white van to pass. He started moving before the white van even got past. He denied that on the witness stand repeatedly. And I asked Mr. Cryer, I said, you understand we're all watching this video together. The judge can see it just as I can see it. Or you really want to say that your van's not moving or that your vehicle's not moving? And he still denied it. And the trial court's findings in the record at page 107, specifically found that the court noticed where the brake lights went off and where the vehicle, you could see that back end drop from the torque of the rear wheels and the vehicle start to move. And she made that determination. Mr. Cryer started to move before the white van ever got past. He'd made the decision to go. She also relied on the testimony from Mrs. Rena Cryer that Mr. Cryer was distracted based on that movement and probably wasn't looking. And of course, Mr. Cryer himself testified that he doesn't look left, right, left, as we're all taught to do. That despite being a truck driver for 27 years, he was not looking left and didn't intend to look left when he pulled out. He was going to look straight ahead where nothing was a danger to him. And so that's why his multiple acts of negligence are the greater than 50% cause of this accident, and why Judge Hollers found that. And in addition, I think why that's the proximate cause. And I think the Bennett case, Your Honor, Judge Davis hit this on the head, that the Bennett case is exactly on point. And I think Mr. Herbert's reading of that case is not quite correct. The Court of Appeals did find that the ambulance drivers were not negligent because there was no proof that their breaches of any alleged duty was the proximate cause. So it's the absence of proximate cause is what made them non-negligent, not that they didn't breach a duty or violate a statute or some other rule. And that's the exact same thing we have here. And it's the same thing that happened in Tennessee Trailways versus Irwin. And it's the same thing that happened in the more recent case, the 2016 case of Hall versus Owens. Where down in Jackson at that Highway 45 bypass that you all may have been to, the person pulled from the red light into the path of the speeding tractor trailer that was going 62 miles an hour. And they said, this is the speed of the tractor trailer over the speed limit is not the proximate cause of this accident. It's the pulling into the path, the same as the motorcycle person in Tennessee Trailways. And I think you say
that we kind of have the case law establishes kind of as a matter of law that the speeding is not going to be relevant if the first act is the negligent act.
If
And that's
there-
kind of where we're going. It's like, it doesn't matter what other negligent thing the person did in response to the first person's negligent act. It's the first person's negligent act that is the proximate cause always.
Well, it's, nothing is always in the law. As I've learned, maybe is the best answer I usually give a client. But the concept is that in this situation, there were, whether it's 3.3 seconds as Officer Ferguson or Officer McFarland found on his stopwatch, or 2 seconds as reflected on the timestamp. It's a very short period of time from the time that Cryer's wheels first crossed the fog line until the physical collision occurred, the impact occurred. And even giving at that time, I would submit to you, and I think the trial court found that Ferguson wouldn't be expected to recognize that Cryer's coming in until at least a significant part of his vehicle has gotten out into the road, maybe a foot, something like that. And so that's even more time. And the perception and reaction time is 1.5 seconds. And so all we have to work here with is 1/2 of a second. And no one can be expected to react in that kind of time. So I think in the facts of this case, with the limited time, I think that rule clearly does apply, that the person who created the situation by pulling into the path, that was the probable, foreseeable cause of the severe danger, not speeding a little bit too fast. And respectfully, Officer Ferguson was not just racing down the road. The speed limit had just dropped a short time before this as they're coming into Smithville. He'd seen the warning signs, but he hadn't seen the actual sign. That is not a serious breach of duty as compared to.
I'm going to use that next time Officer Ferguson or someone of his ilk pulls me over. It just dropped. We'll see if it works.
Yes, ma'am, I understand. And I don't know that it would work to get out of a ticket, but I think a ticket is substantially different than creating a physical risk for yourself and other members of the public. Officer Ferguson,
isn't it negligence per se to be speeding?
It is negligence per se to be speeding,
So
but
why are we saying it's not negligent?
I'm not saying. If that's what I said, that's not the way I intended to say it.
I hear you saying, well, it had just changed the speed limit, so we really shouldn't consider that. And I think we have to.
I think part of the proximate cause analysis is the gravity of the respective risks. And I think that's what I'm trying to articulate here, is that the gravity of not getting slowed down on time is not as serious as pulling directly into the path of a moving vehicle that's 2 seconds away from you.
Does the testimony and the expert's opinion and the objective data establish that if the officer had been going the speed limit, he still could not have avoided the collision?
I think that it was, quite frankly, said both ways during the trial. And I think that that it was either that he could have gotten by a hair, or that it would have still happened. And I don't think that it was, I think it was said both ways at 2 different points in the trial transcript. But the principle is that if he got by at all, it was that he was going to get by a hair. And that's what Sergeant McFarland testified to. And I can get my hand on the site here, but it's that was, and I quoted it in my brief where he said that. Basically, we're just talking about getting by a hair, and that's not safe. And with respect to proximate cause, the issue is probability versus possibility. And the Supreme Court said in its 2013 case of King versus Anderson County, it said the same thing in the 2008 case of Downs, XRL Downs, that both of which are cited in my brief, that the plaintiff must show that it was reasonably foreseeable probability that this was going to happen, as opposed to a possibility. I would respectfully submit that it's not probable that someone is going to pull out directly in your path. It is possible. It's always possible that something bad is going to happen on the road, but I live a short distance from my office, and I tried to count all of the driveways this morning on the way in and the different roads that intersect, and I lost count just a short time after I left my home, because there were so many opportunities for that possibility to occur for somebody to pull into my path. as opposed to the probability. You know, we all,
But might it be that that's why the speed limit drops, is because you're going basically on sort of a highway, and then when you get to a more congested area, the speed limit lowers, probably for that exact reason.
I'm sure that that's,
Increased ingress and egress on the road.
I'm sure that that's true. I don't have, there's no evidence in this record about that, but I wouldn't dispute that conclusion at all, Judge. But the issue here is somebody is 50% or more at fault for this accident. It's either Mr. Cryer or Officer Ferguson. The trial court found that it was Mr. Cryer, and I really submit and respectfully submit that the video supports that, the evidence supports that, the electronic data supports that, the photos support that, and the independent expert witness supports that. And Judge Hollers's finding in that regard and her conclusion, particularly as to proximate cause and who is at fault, it's a proximate cause is a question of fact. And that question was determined by the trial court adverse to Mr. Cryer. And I submit that that's entitled to a presumption of correctness unless the evidence preponderates against it under Rule 13D. And I'd submit that especially in the face of an independent expert who reached the same conclusion as the trial court, the evidence here cannot preponderate against Judge Hollers, and her decision should be affirmed in that regard. I'm out of time. I'd be happy to answer any questions, but thank you.
Thank you, Mr. Rader. Mr. Herbert, your rebuttal.
One thing I wanted to address was that the speed limit had not just dropped. As I said earlier, this argument that he hadn't slowed down yet is completely contradicted by his own testimony and the data that he was maintaining this speed, increasing and decreasing between 61 and 66 miles an hour right up until the moment of impact. And not only had the speed not just dropped, the speed had dropped twice since it was 55 a mile or so, however far back it was, 55 and then 45 and then 40 as they got into the city. So the assertion that it had just dropped and he was just trying to slow down, hadn't slowed down yet, as you said, Judge Davis, I'll try to use that the next time I get pulled over. And the testimony that I cited,
excuse me, your client's view of the oncoming traffic, the officer and the other car was not obstructed in any way, was it?
When you look at the video, as the white van is in the distance, there's another car that kind of passes and you can see the westbound traffic moving. When you can first see the white van in the distance, Mr. Cryer's view is completely unobstructed, and it is clear that there are no cars in the inner lane that Officer Ferguson was in, and that there's a white van in the near lane. As that white van approaches, the only other visible car is the black car. And I would submit that as you see the black car, assuming that anybody behind that black car is traveling at least at a reasonable speed, it'd be safe to pull out. And Sergeant McFarland even testified that the distance that Mr. Cryer pulled out between the black car and the white van was a safe distance, but for the speed of Officer Ferguson.
Did he take one last look to the left to see? I thought I heard.
And I would submit that what appears to me is that as the white van passes, his attention was now on the westbound lanes. If he's already determined that I can beat that black car, the white van passes, he starts to move out, and he's looking at the westbound lanes. That is what I assume happened. He does not recall exactly when and where he was looking at exactly what times because of his age and his intelligence. Something else that I wanted to clarify, I'm sorry, I'm just running short on time. At 40 miles an hour, I cited this in my brief, Sergeant McFarland said even if both of them had their head in the clouds, at 40 miles an hour, this crash would not have happened. We're not talking about missing by a hair. This crash, as it happened, almost missed by a hair. He hits him in the back quarter panel, and Mr. Cryer almost made it entirely across. So at 40 miles an hour, at the speed limit, this would not have happened whatsoever. They wouldn't have even seen each other. As he talks about the still frame image.
To that.
What's that?
Who testified that at 40 miles an hour, this accident would not have happened?
That was Sergeant McFarland. And I did cite that in my brief. And I remember he specifically said, even if they both had their heads in the clouds at speed limits, this wouldn't have happened whatsoever. He also testified that at his speed at 66 miles an hour, he couldn't come to a complete stop. But he also agreed that you don't have to come to a complete stop in order to avoid this collision. And I understand the reaction time and those things all play a factor in it, but it's clear from the video that Officer Ferguson made no reaction whatsoever. And when Mr. Rader talks about, and in the appellate brief, they talk about the photos, I don't know that I agree that you can tell exactly where the patrol car is, if it's equal to or several cars ahead. But at the time that it is several cars ahead, it's only in that position, again, because of his speeding. Everything in this case, the foreseeability and everything goes back to, but for his speed, he would not have been in the position he was, but for his speed, just like the expert in the Monty Penny versus Kiev case. And I think watching the video at full speed is much more enlightening as it happened than it is taking these still frames and trying to make something out of nothing. As the white van passes, his brake lights come off, but he's sitting on an incline. And so the car rocks, and there's nothing, when you watch that at full speed, there's nothing remotely unsafe about it. Mr. Cryer did testify that he looked both ways. He testified that he saw the black car. What Mr. Cryer is talking about is when he asked him very pointed questions about looking left, right, left, and looking again, Mr. Cryer did not answer those, I think, the way that Mr. Rader wanted him to, but he absolutely testified that he looked left, he saw the white van, he saw the black car, and he was looking in both directions to see when he could move. And on the video, it's evident. He waits more than sufficient amount of time for traffic to clear from both directions. And again, the perception of Officer Ferguson, his reaction time is only so short because of his speed. All of this goes back to, but for his speed, his inattentiveness, his distraction, and failure to do anything. In this case, they talk about failure to act with lightning speed, but his failure to act at all is the proximate cause and more attributable than Mr. Cryer. Thank you very much.
All right. Thank you, Mr. Herbert and Mr. Rader, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 2 p.m.
Thank you, and counsel, you may exit the meeting.